So as a little bit of a background, second, now, as a starting point for this book launch event, as we know that innovation is the force that nurtures our daily personal and professional lives. Just stand by for a moment and reflect. In this meeting alone, we are expecting people from across 20 plus time zones, 6 plus continents, and we can all connect and talk without leaving the comfort of our homes and sitting in our room and thinking and reflecting. What makes this happen? Now, this is but one of the many examples of digital innovation and something that I want all of us to keep in consideration when we talk about regulating digital platforms. And in order to ensure, therefore, that we continue to cherish the fruits of innovation, we all come together and we share our perspectives. The idea is that we do it from a comparative and an interdisciplinary perspective. And in this endeavor, I'm very honored to be joined by my colleagues, Alan Grunes, Volker Stocker, Caroline Cauffman, Giuseppe Colangelo, and all the contributors and the discussants to the book. With that, let me take you quickly, in the next 10 minutes or so, I'll give you a brief overview of the contents of what we are going to discuss today in terms of the program, followed by what is an overview on the need for the regulation or non-regulation of the digital markets. I think there's more or less a consensus that we should regulate digital markets, also because it's a very special day today as the gatekeepers submit their report card to the Commission. So as a background, today's presentation is organized as follows. Starting with the bird's eye view on the regulation of digital platforms by myself, we shall immediately break into a panel discussion of about an hour and 15 minutes on competition and intellectual property in the digital economy. We shall then follow with a 15-minute break. Followed by this at 11:45, we continue with a second panel dealing with regulatory measures to rein in the big tech. And we finally close the discussion with a note of thanks, the key takeaways, and a quick glance on the issues that merit further research. Why? Because it is very important to emphasize at the start that this book and the discussion in the next couple of hours only offers a thread in the long-tail discussion on the regulation of digital platforms. And in that respect, today, we are going to raise many more questions than you try to answer. Especially for the discussants and attendees to the Zoom meeting, you have a possibility to ask the questions by raising your virtual hand or typing in the type box. And also, as I said at the start, the event is being recorded. So for privacy reasons, if you might want to keep your cameras on and off, that's your discretion. And yes, thanks to Maastricht University's Open Access Fund, the book, as you might have seen, is freely available on Bloomsbury Collections under the Creative Commons license, so you can freely use it. With this little note, please allow me to formally start the discussion on the regulation of digital platforms. So in the next 5 to 7 minutes or so, what I'm going to do is I'm going to take you through the contents of chapter 1, which is also the idea of the book launch. And this chapter, as if you have read, you might notice it offers an overview of the discussion that flows throughout this book and what is the raison d'etre, the need to regulate the digital markets. Now, I must mention at the outset that the discussion in this book presents the state of the art up until August 2023. And as you may be aware, a lot has happened between August 2023 and March 2024, with 2 important things happening this week itself. First, the Commission's Apple decision, and second, the gatekeepers submitting their report card to the Commission. So what are the key takeaways against this backdrop from the first chapter? First of all, this chapter offers what are the key economic and strategic aspects that shape competition in the digital markets. Secondly, it offers how these economic and strategic aspects are woven into the contributions into this book. So, for example, concepts like open early, close later, platform envelopment, network effects, dark nudges and dark patterns that we frequently talk in economics and strategic management literature. How do the authors in this book bring this interdisciplinary insight into their contributions from a legal perspective, because that's, I think, very, very important when we talk about the digital economy. Now, as a starting point, when the internet was still in its infancy, as we know, the jurisdictions worldwide gave them an assurance of non-liability. That is, the content that would be available on these platforms would be not something that would hold these platforms liable. In other words, it's also called sometimes the 26 words that created the internet, the classic book there. However, things began to change with large computing power, complex algorithms, data with its four V's, namely value, volume, variety, and veracity, and a new picture began to emerge. Why? The platforms could now make meaningful interpretations from the insights that could be generated by the data that was gathered by them from multiple sources. So consider, for example, we have many examples from the GAFAM, but let's take our favorite Google. Google has access to rich and vast troves of data. Why? Search results on Google search, the content that we watch on YouTube, the reviews that we give on Google, and from all the 360-degree directions. All this data together helps Google successfully operate what we call an advertisement-driven business model, whereby the user is cross-subsidized as advertisers heavily pay Google for the targeted advertising on its different platforms. And in that respect, it might also be useful to bring to attention a study which was actually focused on the UK markets, but it kind of gives us a number. The 2019 UK Competition and Markets Authority study, Online Platforms in Digital Advertising, whereby the market was valued at £14 billion, that is approximately £500 per household for the UK market alone. Now, above and beyond these economic factors, it is also important to look at the role of mergers and acquisitions in addition to these sector-specific factors. Why? Because in some cases, it was these timely and foresighted acquisitions. For example, Google's not so expensive at the time, but a very valuable acquisition today, which is YouTube. DoubleClick, Waze, which it then integrated into Google Maps, or Microsoft's acquisition of Azure, which now has a very central role to play when I talk about generative AI, and LinkedIn, our professional network, and Facebook since Meta's acquisition of Instagram and WhatsApp. Now, these acquisitions are a little bit different. They are not the typical killer acquisitions as we would see in the pharmaceutical sector. Rather, as I discuss in another stream of research, they should rather be seen as a string of pearls acquisition. However, staying on competition law and from a merger control perspective, these acquisitions, when they have raised contestability concerns, the Commission has not hesitated to intervene and not hesitated from either remedying or even prohibiting a decision, such as the recent Bookings.com and the eTreveli case indicates. And as a background, also again staying on the point, it is these sector-specific features of the digital economy that has, in a very succinct nutshell, led different studies, whether it's the European Commission study on competition policy for the digital era, the Monopol Commission study, the Furman report, or the Stigler study by Chicago in the US. The consensus that is reached on by all these studies in a nutshell is that in light of the sector-specific features of the platform economy, one must have a nuanced approach to the digital economy, and hence our discussion and debate today. Why? Because these peculiar industry-specific features are leveraged on by the firms through corporate strategy and business model innovation. And these might include, for example, aspects such as digital nudging, the economics of free, open early, and closed later, and not to underscore the importance of user-generated content, and hence its interplay also with copyright, because that is where it is protected. Now, with this little bit of an economic and strategic background, let me give a bit of a bird's eye view of how all the contents, and as you can see, if I were to map it on a map, our book looks a bit like a global map. So how do these contributions from different aspects, law and economics, different jurisdictions, how do they weave together? Because that is one of the big challenges while reading or understanding this book. And please let me also add at the outset, to be clear, that my idea here is not to summarize each of the contributions. Rather, my attempt is to take you through the path that connects and weaves all these contributions by different law and economic scholars from across different continents. So simply put, how do these chapters enter into a dialogue? Now, as a starting point, again, going back to economics, the industrial organization literature reveals that the presence of network effects, direct or indirect user inertia, single homing, make digital markets more prone to tipping. Network effects, in that sense, are a key feature of the platform economy. And in this entire process, when we attract users to the platform, what do these digital platforms use as a starting point? That is content. Content which is offered free of charge, that is without any monetary charge, at least. Now, this content may be news, information, music, or written or audiovisual content, right? And what happens is, the presence of these industry-specific features also creates an imbalance in bargaining power between the platforms, the users, and the sellers on these platforms. And this relatively uneven bargaining position between, for example, the press publishers and the digital intermediaries is a good example to illustrate this. Now, in order to balance this uneven bargaining power, as I discussed in chapter 1 and 13 of the book, the 2019 Copyright in the Digital Single Market Directive created a new neighboring press publishers right for EU-based press publishers. Now, even though this right proved to be of insufficient guarantee, why? Even though it promised something, but it proved to be insufficient because Google could still leverage its position and ask for a different agreement. And this is why the French Competition Authority had to successively intervene and use its competition law provisions dealing with abusive economic dependence to enforce this press publishers related rights. So in that sense, there's also an interplay between IP and competition. On the other side of the Atlantic, jumping on to chapter 12 and the contribution by Alan Grunes and Rosa Baum, the US proposes to balance this uneven bargaining position with the Journalism, Competition and Preservation Act that identifies how platforms such as Google and Facebook free ride of the news that, in the words of the author, may lead to financial collapse of the journalism. Now, staying on copyright and the issue of intermediary liability, the question is, how does one distinguish the current trend of digitization, digitalization, and digital transformation? In other words, how do you distinguish and how do you map it? Now, from the platform economy to the current debate on generative AI, it is the technology-driven mass digitization, whether it's the Google Books project or the HathiTrust project, that has led to global regulatory concerns. As in their contributions of Ashish Gupta and Sneha Mehta articulate in Chapter 8, digitization meant that the marginal cost of making an additional copy of the work plummeted close to zero. This in turn led to a lot of global treaties such as the WIPO Copyright Treaty and Performers in Phonograms Treaty, and is now the current ongoing debate on whether online content sharing service providers should be made liable for the content which is available on their platforms, as is the practice in the EU. In Chapter 9, going on to South America, Gutierrez and Nambaca take a comprehensive empirical study to fathom how the decisions have been taken across 29 national competition authorities in 23 Latin American countries between 2015 and 2022. And they identify that over 50% of these cases and reports concerned digital markets. And even within the digital markets, they find that the competition authorities in Latin America had a priority, and that priority was ride-hailing apps, e-commerce, and over-the-top media services. Staying on digitalization and algorithmic decision-making, I now turn to Chapter 11 by Lee and Philipsen, wherein they discuss, amongst others, the Liu Kuan case decided under the Chinese tort law and how it offers a guidance on AI-related price discrimination and how this is being treated under the Chinese anti-monopoly law. The next logical question that comes is, if data and algorithms are central to competition, then can a mandate such as a data sharing scheme, such as the Commission's proposed data spaces, may foster competition across the digital markets? In that respect, let me take you to Chapter 6 by Margarita Corrado and Laura Zoboli, wherein they discuss how data can be an important barrier to market entry. The authors discuss the European data strategy, and they zoom in a little bit on the European health data spaces as an example. They also offer safeguards to ensure that a platform for data sharing does not remain a guise for collusion amongst competitors. So in that respect, the contribution also has threads with Commission's horizontal guidelines, recently introduced horizontal guidelines, when Chapter 6 is dedicated to safeguards for exchange of information. It cannot be again underestimated the role, and the debate again becomes endemic to the Digital Markets Act, the role and the interplay between the Commission and the national competition authorities. And this brings me to Chapter 2, wherein Ghesi and Magliano discuss the Italian Amazon buy box case, a case that subsequently also inspired an investigation against against Amazon at the Commission level. The Amazon Marketplace and Amazon buy box decisions are applicable, as we see, to all of EU with the exception of Italy, as my colleagues will present in a short bit. Now, the question then is, all these enforcements from different perspectives, whether tort, copyright, competition, in a certain respect, over time, also reflected the limitations of competition law enforcement. Why? In a nutshell, these investigations are long drawn, remedies limited, which means that markets are oftentimes tipped by the time competition authority or the commissions might have reached a decision. This then brings me to the contribution by Oles in Chapter 4, wherein he talks about the Digital Markets Act and very nicely puts it there, how the exclusivity claim of neoclassical based price approach is put to challenge in the digital economy. To capture the issue at hand, Ole suggests that the narrative seems to be transitioning from monocentricity to polycentricity, one that is non-linear and very gradual. Now, why this is important to keep in mind? Because these services, for example, the content that we watch on YouTube, it may seem free on the face of it. Nudging users into watching content and capturing their interest by putting them in information and filter bubbles gives way to dark patterns. This in turn leads to targeted advertising, and which brings me to two more contributions before I give the floor to the chair for the next discussion. Chapter 7 by Pratiksha Ashok, who illustrates how dark patterns and nudges, and she takes the example of Uber to illustrate this, that form the basis of consumer decisions. And the dichotomy is that the consumer is kept in the dark about the criteria for these ratings, even though they form the parameters to take these decisions. And therefore, it brings very legitimate competition and consumer law concerns. And finally, in Chapter 10, Mehmet takes Ole's observation a step further, if I can say, and he talks about the atypical characteristics of the platform economy that have given rise to a global consensus that, yes, we should have platform regulation. And in that sense, he goes on to draw parallels between the US, UK, and EU's approach along the 3 C's of context, criteria, and containment. Now, staying on the EU's choice of Digital Markets Act, and as we know, the basis is Article 14 of the Treaty of the Functioning of the European Union, and not Article 103 of the TFEU. Now, why? Because this offers a more uniform and consistent scope. For this, it is very interesting to look at Birgit van Hoote's discussion in Chapter 3, because she nicely illustrates how territorial fragmentation and piecemeal harmonization efforts have created an uneven situation of access to content by users across the EU member states. So in that sense, it kind of underscores the value of using Article 114 as the basis for the TMA. And once we have the DMA and the DSA, the Digital Markets Act and the Digital Services Act up and running, the question is, then how do you access data, databases, and algorithms? For this, I finally bring you to Chapter 5 by Yana Mazur, who critically evaluates how and under what circumstances can the Commission and the Digital Services Coordinator can make such requests to information. I hope I'm not over time. And with this, I leave to the moderators for the next panel. Thank you.
Okay, good. Welcome to the first panel of this morning. This panel will be chaired by Giuseppe Colangelo and myself. I suggest that Giuseppe takes the lead in introducing the speakers, and then I will afterwards moderate the discussion. Giuseppe, you have the floor.
Thank you very much. At the very beginning, we are going to illustrate the first paper, and actually I'm also acting as a sort of speaker on behalf of Federico and Maria Teresa Maggiolino. As Federico and Maria Teresa were unable to join us to attend the conference, so I'm just briefly illustrating the content of their chapter that relies on the self-preferencing, which is probably the most and the iconic practice in terms of digital markets regulation, as it has inspired several obligations within the Digital Market Acts, as well as other intervention, at least envisaged in other jurisdictions. And it is, again, the main representation on how antitrust investigation has fed, that has inspired digital market regulation. Federico and Maria Teresa decided to focus on a specific Italian case, that is the Amazon logistic case, also known as FBA Amazon, which is relevant at least for a couple of features. The first one is that that is a common feature, that is the debate around or whether we may consider self-preferencing as a standalone practice under competition law and according to the different competition theory of arms. That means investigating whether self-preferencing is different from well-known and traditional conduct, such as refusal to deal, margin squeeze, tie-in, and discrimination. And so the Italian Amazon case is one of these of the investigation that use self-preferencing to describe a practice that potentially may belong to an already well-established theory of harm and conduct. And it's also interesting because the paper also tried to go beyond the debate on how to frame self-preferencing, because according to Federico and Maria Teresa, we may at some point skip this debate and focus on the actual effects of the conduct. And so when it comes to the effects of the conduct, we may just focus on whether the conduct is exclusionary or not. The case at stake, just to provide a brief overview of the case at stake regards a practice undertaken by Amazon, which introduce a sort of tie-in / bundling between the marketplace service and the fulfillment, that means the logistics provided also by Amazon. This could be a case of self-preferencing because allow us to see how a platform may play a dual role, acting as both intermediary and a player within the platform vis-a-vis the rival, the host, and how the platform may address this potential conflict of interest. In this situation, this is belongs more to bundling than tie-in in antitrust term, because actually Amazon is not forcing its own sellers to accept also the logistics, but provide benefits to the sellers that decide to use not only the marketplace, but also the fulfillment by Amazon. But again, according to Federica and Maria-Teresa, regardless of whether we may decide to frame the conduct state as self-preferencing, as a standalone practice, or as a tie-in, or as a bundling, what we should focus on is actually on the actual effects. So run a case-by-case and effects-based investigation. And at the very end, if we may able to demonstrate that the practice at stake is exclusionary, we should not, in terms of actual and potential effect, we should not spend so much time looking for self-preference, favoring, tie-in, and so on and so forth. I will stop here and I will leave the floor to our discussion. I don't know whether there is someone that wants to jump in order to provide questions and comments to the chapter.
Good. Thank you, Giuseppe, for this very nice overview of the chapter on the Italian Amazon case. We will now turn to our panelists. We invite them to share their thoughts on this first chapter, and since it's our goal to foster an inclusive and informative discussion that engages both panelists and the audience, I also encourage the audience to let me know by raising your hand or in the chat if you would like to step in, and then I will try to give the floor to as many participants as possible within the limited time that we have available to us. Good. Who wants to start? It seems that everything was rather clear, but if that's fine, that's very nice.
Sorry.
Yeah.
Somebody
Hello.
raised-
Yeah.
Carolina?
Yeah.
Caroline?
Yeah.
Hello.
Hello. Yeah. I can hear you. Go ahead.
Can you hear me?
Yeah, I can hear you.
Okay. I am Esteban Greco. I was asked to be a discussant about, and I have read this chapter. So I want to make a couple of brief comments about this. I am an economist, and my background is in economy, and I have been the authority in Argentina. I was the president of the Competition Commission in Argentina for a while, between 2016 and 2020. And I think this is a very interesting chapter because brings us a useful insight to how to deal with these kind of practices. I think Giuseppe made a good abstract of the paper. And I think this is an interesting contribution because of how to deal with new practices when there are no clear theories of harm for these new practices that we do not have enough precedents. I can mention that at the same time, or in some other times, there are similar cases to this FBA case in Italy. We can compare this with the case in the European Commission that was closed with commitments with Amazon about almost the same kind of practices. And we can see a very recent investigation that is ongoing, but there are a statement of objections in Mexico about same kind of practices with fulfillment by Amazon and other market players, and this kind of practices. And I think that I have two comments, one more specific, and I think that this, because each of the decisions, if you read the investigations and the decisions, have mentioned different issues, usually that can be classified in one or other theories, classical theories of harm, like Giuseppe mentioned, tying or bundling, and a refusal to deal, and the new or reformed theory of harm of self-preferencing. So I think that the diversity of approaches and elements considered in each decision may have been the result of this lack of new or adapted theory of harm for this kind of practices of digital platforms under competition law, but yet it could have been the result of the lack of convergence in the policy approach to and the adequate legal tools to deal with these practices. Is competition law enforcement the appropriate legal tool, or we need ex-ante regulation? And at the same time that the European Commission was investigating this case, the DMA was enacted, and the DMA includes a provision against self-preferencing. And the other comment is more general because of this point that the authors say that it's better to have a general approach to analysis of effects. And from an economic point of view, I think theories of harm are a key element of antitrust enforcement because provide the link between the ability, incentives, and effects. And for example, without vertical integration, there are no incentives to market foreclosure. So it's important to take into account which kind of legal tests we are going to use to analyze this different kind of conduct. So sanctioning a non-integrated undertaking, even a dominant one, for an alleged discriminatory practice between its counterparts could cause a negative impact on efficiency, innovation, and consumer welfare. Just as an example. So the point of the chapter about applying the general approach to exclusionary anti-competitive practices, I think is very important because it is not possible to enumerate and typify all kinds of behaviors that can emerge in the digital economy ex ante. And anyway, I don't think this is against having specific theories of harm with solid economic foundation. When the practice and precedents go ahead, we can build these new theories of harm and have more predictability to the application of competition law. But I think these are not contradictory issues, and maybe it's a good lesson for other jurisdictions. For example, in Latin America, there are some jurisdictions that only apply specific typified theories of harm in the law and cannot or cannot analyze the effects and the real broadly the real impact of different practices. Thank you.
Right, Esteban. I see that. Thank you very much, Esteban. I see that Jasper van den Boom also wants to respond. Jasper, can I ask you to be very concise since we are already running out of time?
Yes, I will definitely be concise. Thank you for this opportunity, and thanks to Federico Gessi for the chapter. I thought it was really great, and I wanted to jump in on the second comment because I can see that we are trying to reconceptualize how we want to have an approach to competition law, and we want it to be maybe quicker to adapt on the one hand. But I indeed think that the idea of letting go of these preconceived categories may be a bit dangerous because we also have these categories to create some measure of predictability for the undertakings in question, but also for competition authorities themselves. And I think it's really good to open this discussion of how important are they, but we should also, think about how does this impact decisional practice, right? If we don't have these frameworks that we're operating in and we try to find effects in a broad basis, how does that impact the reliability of an analysis or the targetedness of an analysis? But it was a great chapter, so I'll leave it with this for now. Thank you.
Thank you very much, Jasper. Good. I suggest that we then move on to the next chapter that will be presented by Birgit van Houtert. She's an assistant professor at Maastricht University, and she will present the chapter on geo-blocking and cross-border copyright infringement. Birgit, you have the floor.
Yes, thank you very much, Caroline. And also thank you, Giuseppe Colangelo, for moderating this panel. I will now share my screen. One moment. Yes, and also thank you very much to Cauffman and Tyagi for organizing this beautiful project. So my chapter assesses geo-blocking as a tool to prevent the risk of being sued in EU member states for cross-border copyright infringements. The chapter assessment has been made from the perspective of private international law, copyright law, EU law, in particular the geo-blocking regulation, and the right to information and cross-border trade. Finally, I argue my plea for the directed activities approach to jurisdiction. The introduction of the chapter illustrates the use of geo-blocking by the Unver case. When in 2021, two Dutch foundations and a Belgian research association published Unver's manuscripts online, they used the technology of geo-blocking to block the access to their website for internet users located in the Netherlands. Because the copyright on Unver's manuscripts has not yet expired in the Netherlands. However, they got sued before the Dutch court for cross-border copyright infringement. The first table of my chapter on page 72 shows that as a result of the EU's jurisdiction rules in the Brussels 1 bis regulation, the use of geo-blocking cannot prevent online providers of services, goods, or content from being sued in the EU member state in which they are domiciled or established. As illustrated by the Unver case, they can even be sued in the member state in which the co-defendant is established. However, the use of geo-blocking may reduce the risk of being sued in multiple member states in view of the Court of Justice broad approach to jurisdiction based on the mere accessibility of the website involving alleged copyright infringing content or products. However, the geo-blocking regulation prohibits traders to use technologies that block or limit access to their online interfaces, such as websites or mobile apps, based on customers' nationality, place of residence, or place of establishment in the EU. These traders may therefore be sued in all member states based on the accessibility of their website. Nonetheless, considering the excluded services and the definitions of consumer and trader in the geo-blocking regulation, my chapter illustrates in which cases it's still possible to use geo-blocking as a tool to reduce the risk of being sued in multiple member states. However, it also points out the negative effects of geo-blocking on copyright protection, the right to information, and cross-border trade. This slide shows two examples mentioned in the second table of my chapter. First, providers of audiovisual services like Netflix, they are allowed to geo-block access to their own interfaces for users of certain member states. This is particularly useful in case of territorial limited copyright licensing agreement. However, it increases online copyright piracy, impedes the cross-border flow of information, and may be detrimental to the right to freedom of expression. Second, non-profit providers of information are also allowed to geo-block their website for users of certain member states. However, this impedes the cross-border flow of information to the detriment of education and innovation. Finally, my chapter advocates to adopt, instead of the accessibility approach to jurisdiction, the directed activities approach to jurisdiction. This approach increases predictability as regards in which member state one may be sued, since the court of a member state will only obtain jurisdiction if the defendant objectively directed its activities to that member state. Therefore, this approach will also enable online providers of goods, services, and content, even if they are not allowed to geoblock, they can prevent being sued in multiple member states by using, for instance, a particular language, country code, top-level domain name, or providing only delivery in a certain member state. Geoblocking is not a decisive factor under the directed activities approach. Reducing the use of geoblocking would keep the internet more open, which is beneficial for the cross-border flow of information, freedom of expression, trade, and likely decreases online copyright privacy. This is the end of my presentation. Thank you for your attention.
Thank you very much, Birgit. We have time for a very short comments. Jasper again.
Hi, thank you for the great chapter again. And it didn't really come back in your presentation, but it was something that I found really interesting in the chapter, and that is that at some point you observe that because of this maybe lack of protection of geo-blocking, there's also small business users that do not, or businesses that do not enter into the EU at all, if I understood that correctly. And I really wanted to ask how, do you have any insights into how big the numbers of users are that prevent trading? And do you have any ideas what kind of impact this may have on total welfare, but maybe also on, is it a driver of concentration in the EU that only big businesses can enter the EU market while we get less small business users because they are afraid of this? So I was hoping maybe you could elaborate on that a little bit, if that is possible, if we have time.
Yes, thank you, Jasper van den Boom. Yeah, unfortunately, I don't have any figures on that. But as small trading companies, it will be a higher financial risk to enter the EU market, as they could possibly be sued in all member states. So because of the accessibility approach to jurisdiction, so to calculate that in their business plan, it would be a much higher risk as big businesses. They could calculate this financial risk to be sued in many member states. So that's why it may prevent small companies to enter the market. Yes.
Thank you. I find that a very, very interesting observation, and I would love to also maybe hear your thoughts about how to resolve these issues, but maybe we have to discuss that at a later time. I'm not sure. I'll leave that to Karen. Thank you so much.
That would be a very good idea. We might have some time at the end of this panel. Thank you both.
Can we move to the next chapter?
Sure.
Yeah. Okay, the next chapter is delivered by Kian Lee and Niels Philipsen. It's about AI, in particular AI price discrimination. The author are actually investigating whether and when AI-enabled price discrimination amounts to an abuse of dominance under competition law, with a particular regard to the Chinese legal framework. I don't know whether they are both presenting, but because I see both in the chat, but I'll leave the floor to them.
Yeah, Jan, you can go ahead. I understood that you would be presenting.
Yes, thanks for the introduction. And it seems that I'm not allowed to share my screen now.
You can. Please go ahead.
it seems I'm still not allowed to do so. Ah, yes, it works now.
Try now.
Okay.
Okay.
Now it works. Perfect. Yes. Well, our chapter is titled Assessment of AI-Enabled Price Discrimination on the Competition Law in China. The central question of this chapter is whether and when AI-enabled price discrimination amounts to abuse of dominance on the Chinese competition law, and how Chinese competition authority respond to the challenge in digital markets. Before we answer the main research question, let's figure out what is AI-enabled price discrimination. Here we have two examples. A car-hailing app, Didi Taxi, showed higher prices to passengers using an Apple device than it did to those using Android device when they called for the same type of car from the same place of departure and heading to the same destination. Similarly, when ordering the same hotel room on the same website at precisely the same time, a loyal customer was charged more than a new customer. As we can see, the rise of business models based on the collection and processing of big data allows undertakings to charge consumers different prices for the same goods or service at precisely the same time. This technique is called AI-enabled price discrimination, which is short for AIPD in our presentation. Now, we prepared 3 takeaways. The first one, Chinese competition law on paper has several options to address concerns caused by AI-enabled price discrimination in theory. In China, price discrimination amounts to abuse for dominance under anti-monopoly law. Article 19 of the provision on prohibiting abuse of dominant market position specifies the application of price discrimination, while the guideline on the platform economy also articulates the application of AIPD. Please feel free to refer to the analysis in our chapter for further information. And moreover, the recommendation algorithm regulations also prohibit discriminatory practice via recommendation algorithm. For the second takeaway, there is some competition case law in China on price discrimination, but not specifically on AI-enabled price discrimination. There are three decisions on discriminatory treatment. Xuzhou Tobacco, Chifeng Salt, and Yinxingtuo Company were fined for abuse of dominance by means of discriminatory treatment. Moreover, there are also judgment on discriminatory treatment in China. Well, for example, in 2019, there was a case, Liu Quan versus Beijing Sankuai case. Among others, Liu Quan claimed that Sankuai technology took advantage of the industry monopoly and the technical means of exploiting consumers through big data to offer discriminatory pricing. At the end, this case was adjudicated by according to tort liability law rather than competition law. In addition, it's interesting that no plaintiff won the case. We can observe the heavy burden of proof laid down on the plaintiff, and also the challenge to identify discriminatory treatment on the equivalent transactions, especially in digital markets. Transactions vary from each other with the support of the big data and algorithm. The third takeaway, is that like EU, we also need to look for rules beyond competition law to fully tackle the concerns caused by AI-enabled price discrimination. The occurrence of AI-enabled price discrimination includes 3 phases. Phase 1, collection and processing of consumer data. Phase 2, the prediction of consumers' willingness to pay. And Phase 3, application of discriminatory pricing. There are relevant rules in each phase to tackle concerns caused by the AI-enabled price discrimination. Therefore, we can see those rules can serve as ex-ante instrument to tackle the concerns caused by AI-enabled price discrimination in digital markets. We have also done some research beyond this chapter. with a focus on whether current competition law and beyond in the EU and China can effectively tackle AIPD in digital markets. We mainly measure it with a benchmark optimal deterrence. We found that the competition law enforcement of EU and China do not seem optimal because of the inadequate deterrence, the potential error cost, and the high administrative cost. Due to the time limit, I'll stop here. Give back floor to Caroline.
Thanks a lot, Chen. I'm very happy that I can announce Professor Jacques Steenbergen as a discussant for this paper. Professor Steenbergen is Professor Emeritus at the Katholieke Universiteit Leuven, and he has been for many years the head of the Belgian Competition Authority. Jacques, you have the floor. Sorry, Jacques, you're still muted.
Do you hear me?
Yeah, you can hear
thank
you.
You. Well, thank you very much for the opportunity to be with you this morning. And I would also like to congratulate you and the team on the book to have included this chapter, and therefore, of course, obviously, congratulate Quanli and Niels Philipsen on what they did. Price discrimination cases are always difficult, and they require, their assessment requires a view on a number of concepts which basically usually require clarification, like what are equivalent transactions, what are the business partners you have to look at, and that in the perspective of digital, but also in the perspective that I think price discrimination cases and their consequences or causes, like territorial restrictions, are among the most harmful practices to consumers. Therefore, I think this chapter is very welcome, and it is especially welcome as we are also really looking to China in many ways, and it has been suggested that in the preparation of the soft law documents at the European level, it would even have been better to look more at the Chinese examples in how China deals with artificial intelligence, and not only with the assessment of price discrimination. Now, I think that the authors, they go into these issues in sufficient details, as dealt with in Chinese competition law, decision practice and case law, and also, as we just heard from the tort law perspective. I think the chapter gives us useful references to the Chinese regulation on algorithm recommendations. That there is no yet a case practice on algorithms in the assessment of price discriminations in Chinese law, well, that's a fact, and we will just have to be patient. But having the references to the background papers and to the existing practice without dealing with it specifically with algorithms is very welcome. Thank you.
Thank you very much, Jacques. Any other comments on this paper? Not even Jasper. Good. Then we can move on to the next speaker.
Before I start, I just want to check that you can hear me.
Yeah.
Okay.
Good.
Perfect. Thank you, Caroline. My name is Prateeksha, and my chapter is on algorithmic transparency in ranking. Okay. If I do cut out at some time when I'm talking, please do stop me. I will restart. To summarize my chapter, the core contribution and the theme of this is that it's a part of my PhD, which I'm very happy to report that I have submitted and will be defending very soon. The key problems and the key takeaways I brought out three. The first one is to study the regulation of rankings. As the name algorithmic transparency, it is a misnomer. There is no transparency in the algorithm as such. It is the transparency in the data or the data points of information that is fed into the algorithm. To study this, I basically studied the EU and the Indian context. I took a more Western perspective and a slightly developing country perspective from the global South. And in both these jurisdictions, in a more digitally forward in terms of regulation in the EU and digitally nascent in terms of India. In both these jurisdictions, there were market studies that were done that said that, well, this is needed, this is required, this is what consumers call for. And there was that we need more information about the data that is fed into that. We need more transparency regarding this, which has been the standard of the EU to provide more information to consumers. And this was later incorporated in the fairness and transparency regulation, which is often known as the platform to business regulation. Specifically to consumers, this was included in the UCC. And very recently now, we also see it as a part of the DSA in Article 29 as a broader recommender system. In India, too, this was incorporated into specific legislation. But is there a specific market mechanism that works for that? I studied two examples of Uber and Airbnb, where they did use these mechanisms, where rankings are produced, where they did provide the data points that feed into the rankings. However, how much do consumers use? Are consumers affected by this? Do consumers actually go in and read the main parameters? Another aspect of this study was, does it actually balance both IPR and disclosure? To an extent, it does. As algorithmic transparency, as I said, it does not disclose the algorithm. It doesn't disclose the main business model of the companies or of the online platforms. It merely discloses the main parameters or the main data points that are being fed into this. With the word main parameters, it gives a lot of leeway that it doesn't have to disclose in a specific list or a specific weightage of this. It is broadly the main parameters that are fed into this. So to an extent, it does balance IPRs and disclosure. And the third aspect of this was, well, if this is an optimal solution which achieves both business and consumer interest while balancing all the perspectives more centrist way, could this be expanded? Could this be applied in other aspects of transparency, other aspects of algorithmic transparency? One of the ways that I saw was potentially for price personalization, where we see that prices for consumers are being personalized in a certain way based on consumer data, which follows similarly to rankings, where consumer data is used, a ranking is created or a recommender is created for the consumer. Similarly, prices are personalized for the consumer. Could this main parameter solution be a potential way to provide transparency in terms of price personalization as well? The argument I achieved as was yes, it could be a potential solution. We see that I also took perspectives, a few examples from US and China to say, well, their algorithmic recommender, the system, the law is very broad, where we have the Algorithmic Accountability Act in the US, which is super broad and not specific to rankings or recommender systems. Could we have a more broader algorithmic transparency model, which was the final takeaway and the conclusion of my chapter. For further details about how this chapter fits into my PhD and a potential conclusion, we'll wait for that for a few moments. But thank you.
Thank you, Pratika. Good. Any comments, questions? Do I see any hands? Do I miss any? Oh, Jasper again. Please go ahead.
I'll try to limit myself, but thank you for congratulations on submitting the PhD. That's a great achievement. And thank you for this chapter. I thought it was very interesting. And maybe this is more of a question for my own personal interest, but you talk about transparency as a solution to algorithmic problems, but I've always viewed increased transparency more as a way for regulators to detect possible infringements, because I was wondering what, as a consumer, when I realize I'm being squeezed by something, a ranking algorithm, I still can't really adapt my behavior all too well usually. So I was wondering, what is the direct impact of increasing transparency for consumer benefits, or should we see it as something that inspires regulation?
So large consumer regulation has been transparency-based, which is giving consumers more information. And the counter-argument to that is, well, consumers have information overload. With this transparency, I feel like it's only a tool. Again, as I said, it's a more centrist way that achieves the balance of businesses not wanting to disclose anything and the consumers wanting this information. And after that, if consumers, not just as a final person consumer, but users of these platforms, businesses that use these platforms, if they are provided this information as well. The other counter argument that I also researched was sometimes businesses tweak their search word optimization tools to put a lot of words in their search parameters to increase their hits in their rankings. So this could backfire as well. But again, this is one of the tools that they have used. It has worked. It has in a market study that has shown proof that transparency is needed, and it could be expanded with its limitations and drawbacks.
Thank you.
Any other questions, comments? No? Good. Giuseppe.
Okay, the last speaker of our panel is Mehmet Bilal Unver, that is going to provide an overview, a comparative overview of the different approaches undertaken in UK, US, and EU towards the regulation of digital markets. Mehmet, if you are ready, the floor is yours.
Thank you so much. Just starting very soon with my slides. Hopefully I will share very shortly.
Okay, it works.
Hope you can see, I believe.
Yes.
Great. Thanks so much. Hope I will limit my presentation for 5 minutes, which is regarding regulation of digital markets in the UK, US, and the EU. Subtitles, context, criteria, containment, and beyond. As an overview, I will shortly go through major characteristics of digital markets. Then I will uphold a perspective of economic regulation to analyze digital markets regulation across the jurisdictions, including EU, UK, and US. Then I will make a conclusion on them. My rationale behind this is there is a global consensus on shortcomings of the competition law against entrenched market power of digital market players, causing ex-ante economic regulation widely across the jurisdictions. Of course, along with certain regulatory structures and designs, let's say architectures of ex-ante regulations in the field. And that's why I've chosen that way to analyze these digital market regulations, basing my analysis on 3 chain step, or let's say 3-step analysis, basically, including context, criteria, and containment. Before this, I would like to go through a little bit on regulation and the boundaries of this to a short extent. The regulation is a process involving the sustained and focused attempt to alter behavior of others and should consist of certain policy objectives, achievable outcomes, tools, and remedies, which means there must be a sound vision by which the players should be led through a certain process based on certain principles to achieve certain outcomes. This is also relevant for the digital markets. These markets have repeatedly undergone actually competition scrutinies and investigations, including for various reasons, as you know, I mean, like self-preferencing, like restricted interoperability, like combination of users' data across different lines of services. Of course, based on these, as you know, law and policymakers go beyond this competition law precedents with new concerns and remedies. In the EU, we see certain objectives well defined, and of course, the addressee are the core platform service providers, what we know as gatekeepers, under certain thresholds, and they are subject to certain obligations. And my actually the point I picked here is there is an expansive approach which I will later on examine more because of the implementing acts and delegated acts which might expand the regulatory structure already established under DMA, especially under I'm going through updating of the obligations as well as the obligations review, going through non-compliance articles like 17 and 19, which then cause potentially a regulatory engineering, a likely regulatory vacuum, which seems a bit rare in the UK approach for the well-set objectives, including fair trading, open choices, transparency, and their translation into the regulatory structure. As you know, there are step-by-step procedure and chains, let me say, as I will show you a bit later. There are certain exhaustive lists of criteria to determine SMS firms. There are well-defined permitted conduct requirements, as well as those which are not permitted, which also actually function as criteria, kind of evaluative criteria I will show again, and which led us to a less engineered, more principles based, because these provide some criteria, not blacklisted behaviors. When we come to Viecens approach, it seems there is a two-pronged architecture in which there is American Choice and Innovation Online Act, which shows more flexible and clearly elaborated boundaries for the obligations as well as context and criteria. However, when it comes to Access Act, it is quite specified and stringent in terms of drawing the boundaries, and there seems no flexibility, there seems no maneuverability, and there seems more regulatory engineering in the second act. This is my illustration of economic regulation chains, starting with the context showing what products and services are subject to regulation at the principal level. Of course, criteria and containment of tools and remedies, which show a certain mindset as well as an architecture regarding actually how and under which conditions to regulate digital market players. When it comes to EU, there are, of course, these criteria, however, chains. However, criteria chain is just simply set as the thresholds to designate the gatekeepers. There are some indicators, some clues set through actually these articles, like Article 12 when obligations need to be updated, we rely on them. Also, some recitals like 32 and 33. However, those are not criteria applicable widely to hold the structure, and a whole structure seems to be expandable, which would pose some unpredictabilities, even though some feedback channels back and forth, as I showed here. UK approach is more systemic, even though not much well formulated. I mean, not deeply and not prescriptively formulated approach is seen there. I mean, broadly defined context, including digital activities, I mean, on which there must be a digital technology as a core component. SMS designation is more exhaustive. When it comes to conduct requirements, it is less exhaustive, and bespoke categories of requirements are going to be applied, which means there will be some evaluation before remedies within the meaning of containment. Of course, this evaluation is all across the jurisdictions, but it is a mix of actually variety. When it comes to US approach, it is a two-pronged structure we see over here, especially in the criteria. I mean, going through Access Act, the de facto criteria is just the thresholds to designate the players, like in the EU. These also can pose some unpredictabilities, in terms of enforcement. To conclude, well-justified boundaries within and across the chains of context criteria and containment are of key importance. This is more visible in the UK, not totally invisible in other jurisdictions, but just my point of view is actually looking at the picture from an architectural point of view. Sometimes very well formulated obligations might miss this holistic approach. When it comes to EU feedback effect, going and come back and forth, might be useful, but still would be overshadowed by the regulatory structure, which pose some unpredictabilities, as I said earlier. US approaches in between these two jurisdictions, but still can pose some kind of regulatory engineering problem, as I told. Thank you so much, and I will take up any questions and feedback.
Thank you, Mehmet. Do we have comments? I see a couple of hands raised by Oscar and Volker. Oscar, you want to proceed first?
Yes, sure. Thank you so much, Giuseppe. And thank you, Mehmet, for your presentation, for your enlightening chapter. And I'm curious if you can explore a little bit more the concept of regulatory engineering. I mean, what do you exactly mean by that? Because I understood that this term is used in a negative way from your perspective, but if you can provide a little bit of details about it, it would be very helpful. And secondly, about the US approach analysis you carried out in your chapter, seems to me that is really based on bills that have been proposed, but that are not that likely to be passed. So basically, your analysis might be eventually be different from the actual situation on the ground in the US. And I was just wondering if you agree with my perspective or not. Thank you.
Thank you so much for these questions. First of all, in terms of regulatory engineering, yes, it sounds not that great, actually, as a process and as potential outcomes. As a process, I mean, there is not so much clarity within the meaning of EU approach. For example, in terms of burden of proof, I mean, if it is going to be reversal, I mean, just back on the EU Commission, or just will stay on the players forever. I mean, which means there might be definitely clearly less regulatory dialogue, and there would be some regulatory uncertainties, which I highlighted within the meaning of this architecture. this would mean there would be more regulatory engineering, kind of, if not black box type engineering, but unknown process we might come across in terms of steps and procedures. There are very well-defined objectives. When it goes actually outcomes, it is less clear. When it goes to obligations, definitely very well clear clarity happens to be, and very well formulation happens to be. But if the whole structure is not clear cut, these very well formulated actually obligations would bring out some problems when it goes into the process. And that's why I emphasize as a regulatory engineering. It might come back with some benefits, but also some surprises. Some benefits come back through feedback effect from the implementing acts, delegated acts, and investigations, but it is not definitely not certain, not guaranteed. The reason is EU is bringing up a new model, totally new model, definitely driving something from competition law, but it is a kind of actually on its own. And that's why regulatory engineering would be able to come up with some unexpected results, if not totally and entirely. Regarding US approach, definitely it is unlikely to, to be passed. But after this, actually, EU as well as UK approach, because in the UK last year we have got a recent bill, and after all these, there might be maybe more steps going forward. And this is what we have, honestly, on the US side. That's why I kind of actually approached to the US based on those bills, and just I wanted to raise why interoperability is actually kind of handled in a separate act with more stringent and specified obligations, whereas the general discriminative and anti-competitive behaviors are addressed in another act. This causes also another structural problem I would like to raise mainly, but I agree with you in terms of, it is quite unlikely to be an act, unless there might be some kind of indirect or long-term pressures on them to make them as an act. Yeah, thank you.
Thank you, Mehmet. Volker, do you want to jump in? Then I will ask also Jack to raise its question, and Mehmet, you may answer to both our following discussion. Thank you, Volker.
Thank you so much. Yeah, thanks, Mehmet. Great to see you, by the way. Thanks, everyone, for your excellent chapter contributions, and congratulations on the book publication. Yeah, so my name is Volker Stocker. I'm an economist doing research, often interdisciplinary, on the economics, evolution, and regulation of digital infrastructures, platforms, and technologies. And so I have maybe a different angle here. I have a series of questions and comments, and Mehmet, I would love to share them with you via email, I guess. Makes more sense, and I will focus myself on 2 questions.
All right.
So I'll keep it short. This will be regarding the adaptability and dynamization, let's say, of regulatory frameworks. So I really like your chapter and the comparative analysis. I think this is very valuable for many. I recall you wrote that existing approaches in the EU and the US should be reconsidered. And yes, so generally speaking, of course, platforms and ecosystems evolve rapidly. Their evolution is fueled by ongoing technological advances, and we've seen just recently, of course, the emergence of generative AI and new ways to tap and make unprecedented use of data, for example. Now, this gives rise to sector dynamics and, let's say, challenges that perhaps are also unprecedented and perhaps not covered yet in the frameworks and the regulatory text. So 2 quick questions. First, how adaptable and evolvable are these frameworks you considered? And how do you think can or could the required evolvability and adaptability of these frameworks be best achieved? Big questions, Mehmet.
Thank you so much, Volker.
Mehmet, just a sec. I would ask also Jacques to provide his feedback and question, and then you will have a couple of minutes to answer to both of them.
Yeah, great. Yeah, why not? Definitely.
Thank you. A key issue when designing the DMA was to find the right balance between a system that could be applied ex ante and much faster than it is possible under antitrust enforcement, and having on novel issues a regulatory dialogue. Inevitably, you then get the criticism that the system is comparatively rigid. And I'm still convinced that that is necessary in order to have a more speedy dealing with the issues. But on the dialogue, I think that what we have seen until now on the designating process shows that there is real exchange of views and dialogue with the undertakings concerned. Now, how that will develop when we now pass tomorrow, or rather now in the enforcement phase, remains to be seen. But I think there is a real and a real discussion with the undertakings involved with regard to the assessment of their practices.
Yes, exactly. Yeah, I mean, I can take the floor if you like. Yeah, maybe regarding all of the questions, I can take a broader point of view, perhaps, then actually slightly get into the questions, maybe not taking too much time. My point of view is actually bringing out the risks. The structure imposes a certain way of understanding, a certain mindset, and certain risks. I mean, when it comes to EU, there are some gaps and deficiencies within the regulatory structure or architecture, broadly speaking. In particular, I mean, when it comes to criteria, for example, the very well-defined objectives of fairness and contestability, how to translate them into practice, into obligations, and how to evaluate before going into the obligations, let's say containment of tools and remedies, is not that clear. Even though I believe, as said by you, Jack, I mean, there might be, and there is, I am sure, going on exchange of views. It is something would come up actually with nice and definitely merits when it comes to actually enforcement. But from an overall perspective, structure is there and can hardly be changed. Also, regarding Walker's question, I mean, it makes things a bit difficult to adapt against this structure, because structure imposes a certain way of understanding and implementation. Implementing acts and delegated acts would make some effort to fill these gaps, but it would make kind of spinning around and regulatory engineering, as I said earlier, which would make players a little bit confused, and which would come up with some unpredictabilities. I mean, the structure is definitely, I mean, is fraught with some adaptiveness and evolvableness problem, which can be definitely mitigated, but not necessarily fully because of the structure inherent in DMA. And how to best achieve, I mean, best adaptive and dynamic actually environment is still there. I mean, there would be some implementing and delegated acts, but it would hardly change the criteria applicable to players, which means there are some kind of very top level guidance, like under article, I mean, recital 32 and 33, as well as some guidance actually when we pick from somewhere across the DMA, but not a holistic approach, not the criteria applicable to evaluate to what extent and which obligations to apply, what kind of business models is not there. This can be identified later on, but there will be some discrepancies and inconsistencies with the regulatory structure, and that is my point. Of course, from a, I mean, business and industrial economics point of view, there will be some other complements, but my point of view is just raising the risks. Thanks so much. If this is helpful.
Thank you. Karen, I guess we are going to conclude our session.
Yes, unless there are any other urgent questions, everybody satisfied with the answers received? Yeah. Good. Then there was Jasper who still had some questions for Pratisha, but I suggest that you contact each other directly after this meeting, and that you have a nice exchange of ideas between you. Good. In that case, I would like to thank all the speakers, all the discussants for your valuable contributions. It's been a real privilege to moderate this panel. We have had very interesting, profound discussions, and we managed to stay within the allotted time. So thank you very much. We will now have a short break and we will resume at 11:45 sharp with our second panel on the regulation of big tech. See you in 50 minutes.
Okay, shall we, quick introduction, Oles, you're almost there. So welcome back, everyone. Hello. To the panel, the second panel session of the day, which has the intriguing and convincing title, Regulatory Measures to Rein in Big Tech. Given today's compliance day for the DMA, of course, this is superb timing, well planned. Kalpana. It's my pleasure and honor to moderate today's panel with my esteemed co-moderator, Alan Grunes. As we saw in the first panel this morning, we divided our tasks. We will moderate, I will moderate the chapter presentations and the speakers, and Alan will moderate the discussion afterwards. I think that makes sense. So we will have first the chapter presentations by the contributors, followed each by the discussion through panels of 7 experts. They pose questions, offer comments, and provide further insights. So this interactive format, I think, as this morning, shall make our session today not just informative, but also a lively exchange of ideas. Depending on the remaining time, we will have an open Q&A after this, because our goal is, of course, to foster a vibrant dialogue that reflects the richness of the book we are here, of course, to celebrate today. Now, let's start with the first speaker, is Oles Andriychuk. He's a professor at Newcastle University Law School, and if I may say so, Oles, host of a very highly recommended YouTube format. Oles will present his chapter titled Digital Markets Act, Tailoring the Tailors. Oles, floor is yours.
Thank you very much. It's a pleasure and honor to contribute to this book and obviously to this meeting. I have to apologize for this unconventional settings. I'm traveling to another later today. Volker, I just wanted to say that the inspiration for the YouTube format comes from you, and you do amazing for quite a long time. Thank you for the direction in this way. Speaking of the contribution, I think I belong to the majority of those people representing broader competition cluster who believe that the traditional ex post toolkit. Can you hear me?
Yes.
Who believe that traditional ex post competition toolkit is not sufficient in relating successfully digital markets. And I believe to the minority of those supporters. I belong to this minority of those supporters who adhere to more kind of cynical or Machiavellian camp of the new regime. And the main features of this more cynical approach is that it cannot be applicable comprehensively, that the long catalog of obligations of the Digital Markets Act are impossible to be implemented in their totality, And that's why the Commission has to apply their new discretionary competences selectively, based on the priorities which somehow which channel normative presuppositions about the new regime. And the major question is, or there are several important questions. The first one is, does the Commission and do the Commission enforcers themselves know what should be the selected priorities, how they should be integrated with the broader digital agenda of EU and UK for this matter as well? And the second important issue, the second important issue is, of course, what will be the end result, and if how should we manage expectations, in particular of business users. Proposition is, my understanding of the Digital Markets Act is that business users are not entitled to the implications coming from the gatekeepers' compliance with their obligations, if I may say this equilibristic phrase. These are just corollaries, these are just contingencies, and that's why I'm very critical about private enforcement of the Digital Markets Act. I think we have designed this fruit hanging very low, only to remedy the asymmetry of information and power between public enforcer and gatekeepers. If we extrapolate it to business parties, business users, particularly if we take into account third-party funded litigation, and all this rent-seeking toolkit which we witness so pervasively in export damages cases, I don't think it will be a prudent way to go. So for me, unlike with ex-post competition law, where the more the better, I think the DMA envisages and presupposes only selected target. For this, you need a vision. So this broader discretionary power require clear normative priority setting. So we give the tool, we design the tool, maybe it's for the next commission to have it more ambitious, kind of understanding of what the priorities should be. I think the discussion has been channeled over the last 2.5 years to the question whether we need it or not. And we didn't use the time very prudently. Rather than asking this broader normative first order question, whether we need a new regime or not, we should be rather focused on talking about how to implement it, what to expect, etc. So these are the key messages underpinning my contribution. Thank you very much again for the opportunity, and apologies again for this unconventional format. Thank you.
Thank you, Olis. Do we have questions or comments? I see Oscar. Go ahead.
Yeah, thank you. Thank you so much. Hi, Olis. It was a pleasure reading your chapter. I really enjoyed it. And it's always a pleasure reading your output of research. And anyway, moving to the substance, I was curious to know whether this movement towards polycentrism in competition law that you so successfully analyzed and presented in your chapter might not as well come with some risks, especially from a theoretical and academic perspective. I mean, once we bring in other policy goals, such as, environmental issues, or reasoning that is not strictly related to competition law and economic analysis, don't we also fear the risk of losing mutual understanding between experts and scholars? I mean, this is already a problem we are facing right now. But in the moment we acknowledge the fact that polycentrism should stay here with us and should be part of the discussion, I really see a huge problem of not understanding each other and eventually not being understandable to courts and practitioners eventually. And not to mention the fact that players and economic actors need to, predict somehow how competition law may be implemented in the medium term. Thank you so much again.
Thank you very much, Oscar. It's always a pleasure to see and hear from you. I think that's a very legitimate question, and I fully share the concerns. I must note that the position adhered to in my contribution is by far the most radical one. So I dare or have courage to say explicitly things which not many would say, not because they don't agree with me, but because precisely of the matters related to legal certainty and continuity. So I think it's easier to talk about DMA from the perspective of continuity, and we see all formal boxes are being ticked by the Commission DMA enforcement team. So I wouldn't somehow copy paste what I'm saying now to the kind of the agenda setting of the Commission and CMA for the matter of the Digital Markets Competition and Consumers Act. But the concern is valid. I see it's more relevant, obviously, to ex-post competition law, where the continuity is much more mature and the expectations, therefore, are much more established. Whereas DMA is terra incognita. There is no textbooks. There is no, we are in the avant-garde of this process, we and the UK, and that's why we are doomed to introduce new policies and new vision. But of course, it is embedded much more in the traditional legal and economic thinking and toolkits than my presentation make it appear to be embedded. I exaggerate intentionally just for the sake of time and because we are in such a closed format so that we somehow can abandon this rather self-evident matters.
Okay,
But
thank
I
you
agree
very
with
much.
you. Yeah.
Okay, and Jacques, you're next.
Thank you for the chapter. Terra incognita, I would not exaggerate that, because we even have the criticism that many of the concepts, especially in the Articles 5 and 6, are almost copy-paste from or a summary of existing case law under Article 102. So there is guidance to be found in the antitrust practice. But I agree with the statement that private enforcement might indeed be difficult. The main threat to the system is a tsunami of complaints, and more even than a tsunami or a large number of private enforcement actions. But for judges confronted with a private enforcement action, I think I can only recommend to refer questions to the Commission. Thank you. It's also, I think, the most mobile intervention in a book launch I've ever seen, because if I look correctly, it all comes from a train.
It is truly remarkable. I guess I have one moderator comment, which is the ex post litigation route. The question is always, are you too early or are you too late? Can you ever get to the sweet spot? With regulation, such as DMA, it seems to me that a lot of it, as Jacques said, builds on what's actually happening now, and then it tries to future-proof possibilities that we don't know about. Treat me as a skeptic about the ability to really future-proof a regulation. I don't know if you want to respond to that or not, but since we're running a little over, but go ahead, please.
Just 30 seconds. Thank you very much, Jacques, for these observations, for concurring with the points. I'm very grateful for this. Alan, I think that would be exactly the criticism I would channel to my peers who are on more Tommaso de Compostela kind of side rather than Machiavellian perspective. I don't want to degrade the DNA of digital markets. I want it to be much more cynical, pragmatic toolkit facilitating broader European or UK digital agenda, be it promoting EU, UK big tech or something more visible. But that's
please use your mic.
only adhere to selective rather than comprehensive enforcement, and thus minimizing all the potential unknowns of the new regime. But yes, future-proofness is inevitable here. And in this, for this matter, just last point, UK equivalent of the DMA, I think, went even further with this kind of predictable features. And this is one of the designation criteria of the DMCC is 5 years forward-looking, crystal ball gazing, in order to designate the gatekeeper, the undertaking with strategic market status, which is completely unreal, which is completely, which undermines the very philosophy of entrenched market status. When the company is already entrenched, what's the point in looking forward? And I think it will paralyze it at some point, or it risks to paralyze the enforcement of the new regime in the UK. But I hope I exaggerate, I'm panicking, I ring the bell continuously about this feature of Section 5, but hopefully it's not as dangerous as it appears to me at the moment.
Thank you very much. Oles, it worked quite well. So the train and the connectivity. Thanks so much for the discussants, for their comments. Now we move on to a second speaker, Joanna Mazur. Joanna is an assistant professor at the Faculty of Management at the University of Warsaw and will present her chapter, Data, Databases and Algorithms under the DMA and the DSA. Joanna.
Yeah, hi everybody. Can you hear me and can you see my screen? Okay,
Both.
great. Okay, so I tried to answer the points that were mentioned in the email in terms of what should we include in this very brief presentation, and it's great pleasure to share this like the very brief summary of this circa 20 pages with you today. So the core theme of my contribution is actually very much included in the title. So it is about access to data, databases and algorithms in DMA and DSA. And the idea was to somehow analyze this solution, so zoom in on very particular aspect of enforcement. So I think that I hope that Oles's chapter actually provides this broad overview and very like conceptual perspective, and what I try to do in my chapter is to dig into these little details about this particular aspect of access to mostly data and algorithm as something what is actually necessary for effective enforcement, and I try to show what are the potential challenges with the way in which these provisions were structured. So the key problem is the question of to what an extent actually the way in which these provisions were structured is coherent, and to what an extent it can ensure that the enforcement will be effective. And yeah, I have some doubts in this regard. And in order to present them, what I do in the chapter is first to analyze the provisions and then to somehow compare them with what we have under the competition law on the basis of few criteria, out of which some you can see here in the table. It's about the scope of these provisions, about the purposes of the access that they actually allow, and the most important thing, so who and what can actually access under these provisions. And the first of the differences which I would like to indicate between what we had and what is in DMA and DSA is the question of terminology. So we seem to abandon this approach in which we look broadly at information, and under this term information, far use databases and various types of sources can be actually understood to the solution which precisely indicates some of the types of information which can be or should be accessed when it comes to the enforcement. Mostly it is about the commission. So it is about the types of information data that the commission can request. And here you can see the examples such as directly indicating algorithm or explanation on algorithm as such types of information which are included in these provisions on access, which I believe might be a little bit problematic considering the fact that algorithms, for example, are not defined in the definition sections of neither DMA or DSA. Then the second aspect that I would like to somehow highlight, also considering who and to what can get access under these provisions, is these novelties which are present in DMA and DSA, with here the example of the vetted researchers that are allowed certain level of access to some kinds of data under DSA, which somehow breaks this monopoly which we have in terms of the enforcement under the competition law. So to summarize the key takeaways, so firstly, I believe there are some problems with the terminology used, so they can raise interpretational doubts in terms of how should we understand, for example, algorithms, whether they should include the source code or no, or should they be understood more as a descriptive information about how certain technological solutions work. And this is something what I describe on the basis of the example of Polish case law when we had this kind of problem, and this division between the algorithm and the source code was actually noted by our courts, and it caused some problems in terms of what actually was provided on the basis of these proceedings. Then in terms of the overall structure of who and to what gets an access, what was also present in Oles's presentation, of course, somehow follow the competition model in terms of the special role of the commission in the enforcement, with some significant differences, such as, for example, the presence of vetted researchers. And the third main key takeaway would be that if there is any novelty or innovativeness in this framework, it doesn't seem to lie that much in these provisions on the access to these more technological types of information that I'm analyzing in the chapter. It's more in the area of what can be used to actually shape the market, not necessarily to enforce these legal acts. And that would be all. Thank you very much for your attention. And I think I managed to squeeze it in 5 minutes. So.
Excellent job, Joanna. Keep getting us back on to the timing. Questions or discussion? Fernanda?
I am the discussant. Hi to everyone. Thank you very much for this meeting. Joanna, nice to meet you. A pleasure. Well, Joanna is concerned with provisions about access to algorithm and data for the purposes of enforcement. This is the power of the Commission to request information as documents, data, database, algorithm for investigations, and to monitor the compliance with the DMA and the DSA. In particular, she focuses on data, database, and algorithm. It implies that the European Commission and any agency at the end, because I'm thinking on agencies of my region. I'm from Argentina, so I'm concerned about agencies in Latin America. And the European Commission and these agencies and agencies around the world are forced to understand at the end the value, the quality, and the meaning of data involved in mergers, cases, and processed by gatekeepers. Then what we know at this point of this discussion, on the one hand, today we know that data accumulation implies market power, and on the other hand, companies and organizations on collecting, storing, and managing personal data must comply the GDPR in Europe and data protection legislation wherever we have in different countries. So authorities need to determine the kind of data collected and proceed that likely contributes to the strengthening of a dominant position or with exclusionary effects, but also the fact that the data could have been collected and processed unlawfully. So this implies basically different regulations and different authorities, but today we all know that competition agencies and experts are exploring the intersections between the two the two legislations and agencies. And in fact, the DMA indicates that the data protection and privacy interests of end users are relevant to any assessment of potential negative effects of the observed practice of gatekeepers to collect and accumulate large amount of data from end users. My impression, however, is that we are still far from having a complete understanding of the issues we seek when addressing the intersection between competition and data protection. There exists, of course, and there is a large discussion around it, but and there exist some new theories of harm for this intersection, but in fact, the implementation is not obvious, and we see that there are just a few practical cases using these theories of harm. So finally, I thinking on lessons of this article, Joanna's article, for other agencies in the world. And my point is that agencies should therefore be empowered to access data set, algorithms, but also agencies need a clear view of the competitive concerns that they need to address because of the challenge that it implies. Thank you very much.
Thank you, Fernanda. Joanna, you want to respond?
Yeah, so I definitely agree. Like when we're looking at the, I think, yeah, to a great extent at the decisions on, for example, murder cases in European Union, which concern big technological companies, when data protection appears there, it's usually in the context like, okay, there might be data protection issues, but we do have data protection laws, so they would have to comply anyway. So therefore, we are not seriously dealing with this topic because we somehow assume that it's like a different area. And yeah, I definitely agree that it might be problematic approach. And also, like in terms of the bigger context for this chapter, I think there are like on the very basic level, what I think is that some of the obstacles that appear for the enforcement at the very basic level of collecting necessary evidence somehow underestimate the role of the provisions which define how this access can look like. And therefore, this was like one of my main motivations to dealing with this chapter, because when we look at the competition law and this broad approach to like having access to information without giving any particular categories of information, on the one hand, it's good, right? Because there are no limitations in terms of what the Commission can request. But on the other hand, we then might have some doubts whether something counts as information. And also, if we don't have like specific categories, what we seem to experience is that the Commission is actually drowned with the amount of data and information that are not answering this particular questions that the Commission tries to answer, right? So maybe having these particular types of like algorithm databases, information which Commission can request can answer this problem. But on the other hand, and I go back to one of my main conclusions from the chapter, if we don't define what these types of information mean and what it should be covered by them, we end up again in some kind of like too general, too abstract approach, right? So yeah, I think it's like a conundrum, and it goes into the quite pessimistic views that OLS has had about the whole architecture of these new solutions and how probably ineffective it will end up to be on this small scale of this particular part of this particular type of provisions. I think, yeah, I share these concerns in terms of what they might bring and what actually can be like somehow wasted potential, right? So yeah.
Wonderful. Thank you so much. Super interesting. And probably there's lots of potential to follow up these discussions. Now, we proceed to our third speaker. It's Subhashish Gupta. Subhashish is a professor of economics at IIM in Bangalore and will present his chapter on regulating digital platforms, intermediary Liability and Content Moderation in Copyright Enforcement, a chapter he co-authored with Sneha Mehta, an attorney and legal professional specializing in IP, media, and entertainment law. The floor is yours. Please take it away. Can you unmute yourself?
Right. Hopefully everybody can see this.
Yes.
Right. So this is joint work with Sneha Mehta, and it covers copyright enforcement and intermediary liability in India. Actually, in a way, Sneha and I were sort of put together by Kalpana, and she helped a lot with sort of hand-holding us. Sneha, unfortunately, hasn't joined us today, but she is the lawyer and I'm the economist. So it's a sort of a contribution between the two of us. So very short presentation. So I'll talk a little bit. This is myself as the economist. And the second slide, I'll talk about intermediary liability and the legal status in India, but probably not very well. So question is, well, we all know about copyrights. We often suffer from things being copyrighted. What can be copyrighted seems like the list is quite extensive. Books, music, visual art, software programs. Software programs, interestingly, I mean, some of you might be dealing with this, cannot be patented. So one way of thinking about copyright design is to use these three terms, height, width, and length. Height refers to how novel a particular innovation is. Width is more about the scope. For instance, if you have a book, sometimes you're allowed to copy a few pages, or you might be allowed to copy some of it. So that's what is basically the width. And length is the time of the length of the copyright. How long does the copyright last? And so typically height and width, there's been more interest in length rather than height and width, I think. Generally, this is my impression. Actually, all three should be sort of discussed together, but generally, if you look at the issue of length, the issue is if it's too long, then of course the producer enjoys the protection of a copyright for much longer, but that sort of reduces the welfare of consumers. So there is an issue of trying to find the right balance between how long the copyright should last. And another issue, of course, is that if you are thinking of what is the value of a copyright, so you would have to then say, okay, it must be the present value of the stream of earnings that I would get from this copyright. And obviously, the longer the copyright extends into the future, the less valuable will it be. So if 100 years from now, even if you have a lot of money, but given a particular rate of discount, the value of that would be much lower now. So at some level, very long copyrights are not particularly useful even for the producer. But of course, nowadays, we're not talking about individual authors, etc., but maybe more about corporations. And then, of course, it might be a very different story. And then I go on to discuss about public goods. I don't want to get into that here, but essentially, again, when you talk about protection of consumers versus producers, typically copyrighted goods are non-rivals. Say music, you can listen to a song, it won't hurt anybody else if they listen to it as well. But you can prevent that person, another person, from listening to it. So in some ways, it's once a product has been produced, it is kind of useful or kind of welfare enhancing to let as many people be able to enjoy that particular piece of work. But then, of course, there's this issue that, okay, that may not, that may be harmful for the incentives of the producer. So much about copyright. So couple of other issues I sort of discuss about competition law, relationship between competition law and copyright. Might seem that the two are antagonistic to a certain extent, because after all, copyright seeks to, just like patents in some way, produce a monopoly of some length. But nevertheless, both of them, competition law and copyright law, can be thought of being complementary in the sense that both try to a certain extent, improve consumer welfare. The other issue that I dwell on is the relationship between copyright and development. A lot of times we are, as a developing or an emerging economy, lectured on the need for copyrights for development. But when you look at the countries which have the most stringent copyright laws, they're usually not among, they may not be among the most developed. So this link between copyright and development seems to be sometimes a little stressed too far. And a lot of the things which are actually copyrighted, particularly say in a country like India, may actually hinder development. For example, given the cost prices of journals right now, academic journals, it's almost very difficult for a small, lower level tier 2 university to be able to afford them. Finally, free speech is an issue in India. It's becoming more and more of an issue. And sometimes the area of copyright and free speech obviously intermingle. And one way, given that it's fairly easy to copyright things, so it might be one way of curtailing free speech. Well, nobody has tried it yet. But if you look at the sort of the discussion in India, I mean, the social media is a very fractious area. Quickly going on to intermediary liability, platforms are intermediaries. So there's this little bit of a query as to, are all platforms intermediaries? Are all intermediaries platforms? Neither, I think, is true. But nevertheless, so if you look at it from a theoretical position, so I think the idea which was used was that platforms are gatekeepers, not in the terms of the DMA, but more like an auditor or a bartender, somebody who prevents wrongdoing. And so that was the way to think about intermediary liability. In the case of India, the two acts which are concerned with intermediary liability are the IT Act of 2000 and the Copyright Act of 1957. So as you can see, the Copyright Act actually preceded the IT Act, so which is as it should be. So in some sense, the digital world has caught up slowly. So at the time of the Copyright Act, there was the question of this IT and what it would mean for copyrights, etc. wasn't there.
So may I quickly remind you maybe to wrap up, to allow time for discussion? It would be wonderful. Thank you so much.
Sure.
Thank you.
So one of the things which was done, obviously, as it has been going on, so all of these things which I have noted after that, safe harbor, then there were intermediary guidelines in 21, talking about SMIs and SSMIs. And so all of this has been work in progress. And in some ways, it is going to remain work in progress. I'll stop here.
Thank you. Any questions or discussion? And hopefully we'll have a few minutes at the end if people have thoughts.
Okay, then thank you so much. And we move on to our next presenter, which is my esteemed co-moderator, Alan
Okay.
Grunes.
Shubhashish, can you stop slides sharing if possible? Thank you.
Wonderful. So big, yeah, thank you again. And Alan, your turn. You're an antitrust lawyer who advises clients on mergers and acquisitions in several industries, and you also represent clients before U.S. antitrust agencies. Now, you are going to present your chapter on U.S. competition law in digital markets, which you co-authored with Rosa Baum, a lawyer specializing in antitrust and competition law, security litigation and enforcement, and commercial litigation. We are very excited.
Well,
And
thank you.
take it away.
Thank you. And I think this has been a great program so far, and I've enjoyed the book as well. And hats off to Kalpana and colleagues for pulling this together from thought to reality. I co-wrote the chapter with my colleague, Rosa Baum. Our chapter starts with a story and ends with a comment. The story begins with the Microsoft case 20 years ago, more than 20 years ago now. I think it's fair to say that Microsoft established an important roadmap for a monopolization case in what was then called the new economy. I guess we would call it the digital economy now. But for many years, this roadmap sat in the back seat of the car and gathered dust. There was very little focus on monopolization at the antitrust agencies in the US, and very little merger enforcement aimed at the tech sector, as we all know. Meanwhile, the current crop of big tech companies grew and became dominant. And in hindsight, it's not hard to see the mistakes that were made, and we flag some of them in the chapter. Beginning interestingly in the Trump administration, and continuing in the Biden administration, monopolization has again become a priority at the agencies. Both the FTC and DOJ are pursuing what Professor Tim Wu has called the big case tradition in American antitrust. Professor Wu also sees these big cases as part of the innovation cycle. Saplings, in his words, saplings grow into giant trees, and then the path needs to be cleared again so the next generation of saplings can grow tall. There's a little plot twist in the story, and that is the courts, since obviously in the US, the agencies don't control the outcome. Particularly the US Supreme Court is the plot twist here. The American Express opinion seems to be a retreat into a kind of formalism. So there's some tension, and it's not clear how the story is going to end. We take a little side trip in our chapter to talk about the consumer welfare standard and its critics and defenders. It seems impossible not to pay at least some attention to this debate. The current heads of the FTC and the DOJ's antitrust division have been among the critics of the consumer welfare standard. Professor Hovenkamp has been among the ablest of defenders. We next go on a tour of the US Capitol. And we talked a little bit about this in the first panel. This is a story of would have, should have, could have, but didn't. There ultimately has been no success in amending or modernizing the antitrust laws to make them more effective in the digital economy. A number of bills were introduced in the last Congress to introduce things like interoperability and data portability, as we heard, the Access Act, self-preferencing, and gatekeeper status. All of these bills went nowhere. Lobbying against the legislation by a number of the big tech companies and their allies was significant. Reportedly, in the hundreds of millions of dollars were spent opposing these bills, which is remarkable. And by all indications, the lobbying was effective. So I have one screenshot, which I'll try to do with my technological limitations here. I'm not on a train, but I still have technological limitations. So this is an advertisement, if you can see it, that was in Politico in 2022 from a S2992 is the American Innovation and Choice Online Act. It was the bill introduced by Senator Klobuchar, among others. And it's the bill that most closely paralleled the DMA, I'll add. It got out of committee, but never got a full vote in the Senate. But as you can see here, you know, don't let liberal Democrats make China the world tech leader. So there you go. You know, and then the innovation and choice and competition is referred to here as anti-competition, anti-innovation, and just for good measure, anti-jobs as well. So you get the point there. I expect that legislation will be introduced or reintroduced in the current Congress, but in light of recent experience, it's difficult to imagine that it will become law. Having said that, I'll add that politics makes for strange bedfellows, and there are members of Congress that are not natural allies, but who sometimes come together on issues, including issues involving tech and antitrust. What about a new regulatory agency, one concerned principally with regulating digital markets? This idea also has been floated in the US. I think there are good arguments for moving in that direction. However, in the current environment, I would conservatively say there is zero chance that such an agency will be created. And even if it was created, it would face years of litigation before it could ever be effective. And chances, you know, there's at least a fair chance that it would never be able to be effective. So in consequence of that, the antitrust agencies, and I think particularly the FTC, are ramping up their ability to address some of these issues in-house and building up capacities. The chapter ends with a comment. We note that different jurisdictions have different strengths when it comes to addressing abuse of dominance by gatekeeper type firms. In the US right now, agency enforcement is a comparative strength. In other parts of the world, regulation seems to be the comparative strength. Thank you, and that's the chapter.
Thank you very much, Alan. Any questions or comments? Jasper, please go ahead.
Thank you for the opportunity to read this interesting chapter. I think it was a really great overview of developments and issues. And there were two things I was wondering that maybe weren't highlighted as much in the chapter. So there seems to be this paralysis of public enforcement, but I think private enforcement in the US is still quite active. So is there the hope that we can, or that the standards can be developed there that may actually strengthen the position of public agencies? And I was also wondering whether we have the so-called Brussels effect that we discuss here quite often. So now we have in the introduction of regulation in multiple jurisdictions, and will that impact the status in the US, or do you feel that there is some type of exception that penetration will be limited?
Okay, so thank you, Jasper. On the first question, looking historically at private enforcement for years, it was independent of government enforcement. In recent years, it's tended to be, with a few exceptions, very conservative, and has tended to be limited pretty much to follow-on cases after government action. I'm less optimistic that private enforcement, even though it's a pillar of the U.S. law, the way it's set up, is going to push things forward. The states themselves have enforcement ability and have moved in that direction. So I'd say that probably state enforcement, if anything, is what will supply the gaps, if there are any, in federal. And in terms of the Brussels effect, it seems to me that some of the provisions of the DMA will end up, or could end up, being adhered to by companies on a global basis, and so some of that may move over into the U.S. Another example, I don't know if it's the Brussels effect or whatever, but to me the critical year was 2019, when the 3 reports came out, which suggested at least a move by the U.S. To join with the EU and the UK.
Thank you very much. Do we have another question? Maybe quick question or quick comment and quick reply? Jasper, follow up. Do it. Very good.
Sorry for this. I was actually also wanted to ask about that. In 2019, there seemed to be quite some enthusiasm to join in this movement, but then I think ever since maybe the FTC case against Meta fell flat, that enthusiasm seems to have diminished a bit. And you were talking about a resurgence of creating capacity. Could you elaborate a bit on that? Do you have any insights into what their plans are in the short term?
Well, the FTC has brought on technical specialists and has devoted an entire new group to digital issues, which I see as capacity building that they're doing, that they're able to do. I don't think the Meta case, if you look at it, it did restore the potential competition, or it did reaffirm the potential competition doctrine, but it also showed the limitations of that doctrine in the US, which is you have to prove that somebody isn't simply in this case Facebook or Meta is not only thinking about moving into an area, but is poised and ready to, and the evidence wasn't there in that case. Potential competition issues probably are better dealt with under the monopolization statute, because there's a somewhat lower hurdle in the US.
Thank you very much. And perfect timing, actually, to move to our last talk or input of the day. Last but not least, of course, our final speaker of the session is Juan David Gutierrez. I think you present, or Manuel?
We're presenting both of us.
Wonderful. So Juan David is an associate professor at the Universidad de los Andes in Colombia. And Manuel Abarza is an associate lawyer at Estudio Levitt Abogados based in Santiago, Chile. Jointly, they will present their chapter called Challenges to Competition and Innovation to the Markets, Insights from Latin American Cases. The floor is yours. Go ahead.
Well, thank you very much. It's very nice to be here, and thank you everyone for showing up. This chapter starts with a story as well. In 2019, I attended a meeting of Latin American competition agencies where a top official from a multilateral organization said, with regards to digital markets, all the competition authorities of the world are in the same boat. And that question sparked another question, and was, are we in the same boat, really? And my colleague Manuel Abarca, with whom we wrote the chapter, we thought, well, we should get a bit empirical in this instead of making any normative assessments. And that's why we since 2019 until now, we built a database of cases that have been dealt by competition agencies in Latin America and the Caribbean from 2015 to 2022. database is actually published as well, and we have almost 100 cases and reports from competition agencies in Latin America, which means that competition agencies are actually in Latin America active. Almost 2/3 of the competition agencies have addressed somehow issues in digital platform markets, either through their investigations of anti-competitive practices, merger control, or competition advocacy. In the data set, we found that there were some common markets that were being studied, like the ride-hailing platforms, e-commerce, and OTT services. Some jurisdictions are leading the work. Brazil, Chile, and Colombia have the thrust of the cases, but as I said, almost 60% of the agencies actually have a case regarding the digital markets. And I'll move on to the next slide so that Manuel tells us a bit more about the findings. Manuel, this is your turn. Manuel, we can't hear you. You're muted. Okay, I'll continue then. So as you can see, most of the cases that we found are actually ex-ante interventions because they're part of competition advocacy efforts, either to, let's say, undertake and publish market reports about the competition structure and situation in the market, and also about many regulatory projects that have been presented by legislative bodies or regulators that would affect the competitive dynamics of digital platform markets. So it's interesting that the most common activity is related to ex-ante intervention. However, we also found, of course, merger cases and anti-competitive practices. Although this, in the case of the antitrust cases, there are less of them, and they tend to be part of the biggest jurisdictions: Brazil, Chile, Mexico. We found that there were common cases that had been addressed differently by the antitrust agencies, most notably the merger case between Uber, Food, and another platform. I don't know, Manu, if you're...
Can you hear me now?
Mic is on so that you can speak.
Can you hear me now?
Yes, go ahead, Manu.
Perfect. So sorry
we have
for
1 minute, by the way.
For the convenience. So basically, since the arrival of new business models to Latin America reality, it was obvious that the challenge of competition agency could be the assessment of this entry. And this was a convergence between all the competition agency regarding a lot of advocacy opinions regarding especially the entry of ride-hailing apps and their relationship with traditional taxi transport. At the same time, we found some divergences regarding the state of the market and the incorporation of foreign theories of harm regarding the supermarket delivery apps market, both in Chile and Mexico, and especially a very critical point in terms of the relationship between privacy and competition law, where we found a very interesting debate between whether privacy can be considered as a critical input for central markets, and therefore it can be considered or no as a potential excessive regulation of data case in terms of a theory harm of or an unilateral dominance case. And we have, in the chapter, you will see all these challenges, and basically our main findings that you will be able to notice in the chapter. You will see that the ex-ante intervention are most common than exposed enforcement cases. These cases have been pursued more like by the bigger economists and the respective competitions agencies, and the substantive challenge are very similar than the assessments taken by the American and European competition agency, but adapted to each local and economic reality. So, trying to answer the question brought by Juan David, we can conclude that we are not in the same boat, Latin America, than our European and American mates, but we can say that we are all in the same sea. So thank you very much, and thank you for your time.
Great, thank you both. Do we have questions or discussion? And I'll particularly ask any of our discussants who have not had an opportunity yet to speak, if they'd like to comment at this point.
Nicholas raised his hand.
I see. You raised your hand and then you Zoom raised your hand, so very good.
Yeah. Thank you very much. Thank you very much to the authors and to Kalpana for the invitation to be in this very interesting forum. Regarding the chapter written by Juan David and Manuel, I think it's very challenging to analyzing a number of jurisdictions that don't have much in common, I think, more than to be in the same geographical region. We have no legislation, we have cases with different characteristics, we have different sizes of economies, different experience with antitrust issues along the jurisdictions. And well, and you can see, as Manuel was saying, that the enforcement and activity in digital market overlaps with the biggest economies. Well, there are some outliers, but pretty much the biggest economies have the bigger cases. However, and this was thing that was just mentioned in the chapter, but Manuel was a little deeper here in the presentation, that some industries that were ripe for disruption in Latin America have been, you could see a lot of cases, like especially in ride-hailing and delivery apps, that could intersect with some characteristics of the economies in these countries that have a little more informality than the ones that we see in Europe or in the US. And however, the chapter doesn't center or doesn't analyze in more depth those ride-hailing cases, for example. Also, it's also mentioned in the chapter that this more experienced jurisdiction had some prior jurisprudence or prior ideas regarding two-side markets and network externalities, mostly for payment processor cases, and because you have the fintech industry. The fintech industry is also causing a significant challenge for incumbent actors, as well, bancarization and access to financial services in these less developed economies. It's an issue here in Latin American cases. And finally, going to be respective of the time, regarding data and competition and privacy and data collection, I think it could be hard to present that issue, as it's very hard to see that data collection is a competitive variable. Like consumers or the users on these platforms doesn't see data collection as something inherently bad, like the privacy infringement or like the value that they provide to their privacy is not that high. So how could you, I think you have to be like, you have to develop a much more sophisticated theory of harm in order to introduce privacy issues into competition law cases? Are we doing if not, you can see that deterioration of privacy, it's not a relevant issue for competition law. We could see, I don't know, try to do some like the privacy and data collection could lead to manipulation of the behavior of the users, nuisance, or I don't know, but I think that we are very, very in the early stages, at least in Latin America, regarding what are we going to do, or how are we going to embrace the issues of data in competition agency. Just to say a final word regarding the ride hailings and the disruption of some established industry. I think the main issue has been like some lack of regulation or weak regulators in some of the industries. And how, and so my question would be, how are we seeing weak regulators and some reluctance of competition authorities? What about the judiciary? Are the Latin American and Caribbean decisions consistent with prior cases, like in the fintech industry or in the payment processors industry? Thank you very much again. Thank you to the authors.
Okay, response to the comments, and then Esteban.
Just a short thing is that the ride-hailing cases didn't make it into the chapter because the chapter was already too long, so we had to take away that section, and we published it in a blog post that is out there, and it's called Mind the Gap, Assessing Ride-Hailing Apps in Latin America and the Caribbean. And I also agree with Nicolas that there are at least 23 national competition laws in Latin America and 29 agencies. So there's a huge variety among them, and we cannot assume that there's commonalities. And we didn't, of course. We actually tried to compare and contrast, and we found the huge differences among certain jurisdictions, particularly the more experienced ones and the biggest economies with regards to the rest. Regarding last comment of Nicolas about the judiciary does have an important role in some jurisdictions in Latin America because they control what the commissions or agencies decide, but it takes longer than usual for having cases, I mean there is of course previous case law on different markets and in situations that may be similar regarding let's say price parallelism and some abuse of dominance that could be taken into account for these new cases. But I would wait a bit before bringing very earnest conclusions about whether the case law regarding digital platform markets is consistent or not with the judiciary's rulings. I don't know if Manuel wants to say something.
That's okay. Go ahead, please.
Okay, great. Esteban.
Thank you. I first want to celebrate the inclusion of this Latin America chapter and congratulate the authors because of their useful survey of cases. And I think this is a very useful way to approach these issues. I have two comments briefly, and I think Nicolas mentioned these both issues, but I want first to stress that an important issue that the authors mentioned on the paper is the role of digital players in Latin America to enter and disrupt markets dominated by traditional incumbents. I think this is an issue that we have to take into account when analyzing Latin American cases, and agencies have this issue in mind when investigating. The other issue, maybe the chapter stressed the relevance of ex-ante cases, mergers and advocacy mainly. I think that there are maybe a recent trend, more of recent trend, where there have been an increase in conduct or ex post cases, mainly with the emergence of fintechs and companies providing digital payments services and disruptive services in digital financial markets. And this has been a source of new cases. An example is cross-border payment cases in different Latin American countries. And also there are new cases against big techs. Maybe these are ongoing cases, but we can say that we have a kind of tendency in this respect, and the fintech sector and the financial sector on digital platforms, I think is the star in Latin American cases now. Thank you.
Great, thank you very much.
It's a very interesting, the topics that Esteban mentioned, because there is an historical continuum between these two trends. First, the arrival of digital disruptors was part of a first stage of the digital assessment history for competition authorities, because the first answer, or the first common answer by competition authorities consisted in trying to recommend the existence of regulations that did not cause the generation of excessive entry barriers to these sectors. So that was the first approach. But after the consolidation of these actors on the market, there has been, as Esteban said, an increase of cases of more complex and bigger cases against big techs. We can notice cases against Apple, for example, in Chile, cases against Meta and WhatsApp in Argentina. We can see cases against Amazon in Mexico. And these cases, we have talked with Juan David about this, we think that this is related to a next stage of the approach that Latin American competition authorities have taken in order to, after address the entry of new actors into traditional markets, the next stage is obviously whether the consolidation of these new actors can lead to new challenges and, of course, new risk regarding the competition. And the main challenge that we strongly believe is how to address the effects that are already being tested both in the US and the European Union in the Latin American legal language. For example, the theory of harm, for example, regarding self-preferencing as an abuse in itself, that is a language in the European Union. This approach can be different in the Latin American context. So it will be a challenge for the competition authorities regarding how to address this conduct in order to whether this conduct would be a new form of abuse or it will be including into a former and traditional category. And we think that will lead to begin with, a new chapter or a new version of the chapter that we have written, and of course, a new challenge for all the competition authority and the academic community as well. So thank you so much.
Great. So we're already on to the next book then. That's very good. A few years from now. So did you want to make a final comment? I think.
Yeah, just the final very short comment is that it may not be surprising that competition agencies start first with advocacy and reports and then go on into let's say more complex cases, because that's actually how agencies learn sometimes and decide to learn. So maybe they were trying also to learn, and that's why probably they are engaging in more exposed conduct now. But that's just a hypothesis. Thank you very much for your comments, Esteban and Nicolas.
Good.
Okay, Volker, or
Yeah,
Caroline?
I think we should wrap up and thank everyone for an amazing panel, a wonderful event in generally, and then perhaps give the word to Kalpana.
Thank you so much. Thank you for those wonderful contributions, panels, and moderations. I know we are already 10 minutes past the line, but we really have to say something, and that is a big thank you. And also, things, as I promised, that we did not cover in the book, because this is just the start of a discussion. So can I please start with my very dear friend and colleague, Caroline Cauffman, to say a few words, and then we go on in a note of thanks.
Okay, good. Thank you, Kalpana. Thanks also to everybody for all the hard work that you have put into this project. I think that we have seen that there is still ample room for further discussion, and I hope that this was not the end, but the start of further collaboration between us. This project would not have been possible without you, but it would also not have been possible without the administrative and financial assistance that we received from Maastricht University, the Limburgs Universiteitsfonds and Studio Europa. So many thanks also to them, or in Dutch, hartelijke dank. And we are also very grateful to the publisher, Hard Publishing, and in particular to Roberta, who is...
Caroline, you're muted.
And yeah, I was just saying thanks to the publisher, who is represented by Roberta Bassi, who is with us here, and she would also like to say a few words. Roberta.
Thank you very much, Caroline. It is a pleasure to be here. I've really enjoyed listening to the workshop today. I'm a publisher on the HART list, and I look after the competition law list and the law and technology list. So this book is the perfect addition to the HART catalog. I just wanted to thank all the contributors for their hard work and congratulate them on a wonderful book. I hope this will be the first of many. And of course, great thanks also go to Kalpana, Caroline, and Anselm for steering the contributors and also for producing this wonderful volume. And I'll just hand over to Alan now. Thank you.
I thank you, Roberta, for what you've done. Thank you, Caroline. Thank you, Kalpana. I would summarize what we've had to say, but I'm not going to in the interest of time. In the back of my mind, through the whole discussion though, was, okay, talking about the digital economy has been complicated. Yes, we're in the same sea. I think there will be differences as we navigate this. But the next challenge, which was mentioned, of generative AI, is going to be even harder, I think. And so perhaps, Kalpana, when you recover from this book, you can start thinking about that as your next. Thanks.
We have to think it together. And staying on generative AI, because you opened the Pandora's box, I just read that on 16th of January, there was a report, a competition report, which was approved by the Parliament, because I promised to offer some further food for thought, wherein it actually plans to expand the scope of the Digital Markets Act and also cover cloud service providers and generative AI. And early on, another very dear colleague of ours who is not joining us today, but Peter Djok-Pick, has a very good paper which dates back to, I think, July 2023, wherein he talks if ChatGPT, for example, can be covered under the Digital Markets Act. So a little bit of food for thought. Lots of interesting workshops coming together, but I want to use this moment to say a big, big, big thank you to all the contributors and also the discussants, because I think you made such nice comments. You took us a step further. You also kept us giving us food for thought. And as a next step, I would request you to be in touch, read the book, enjoy, and leave a comment if you want. So if you want to make a written contribution or a discussion on the book, you can reach out to any one of us, myself, Caroline, Roberta, Alan, and then you can get your complimentary hard copy. Thank you so much. It's really difficult to say thank you and goodbye, but I think in the interest of time, we have to say a lovely good day, good afternoon, good evening, wherever you are. Thank you and bye-bye.
Thank you so much.
Bye then. See ya.
Thank you.
Thank you.
Bye.
Goodbye.
Thank you. Bye.